Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to look at the case of the Queen and Nur, and there's a couple of reasons. First, this is a case that illustrates how cases around people who may have done very bad things can help protect people who are less morally blameworthy. The other thing is that this is a case where the Supreme Court was looking out for the ordinary gun owner, which doesn't happen a whole lot. Let's have a look at this, but first I'll give a bit of background. So prior to this decision, Section 95, which is possession of a loaded, prohibited firearm or restricted firearm, or one of those types of firearms together with ammunition without having a license and registration certificate. So if the Crown proceeded summarily, it had a maximum penalty of 1 year in prison. And if the Crown proceeded by indictment, it had a maximum penalty of 10 years, but a minimum penalty of 3 years on a first offense. So this is a bit of an unusual circumstance because it's up to the Crown how they want to proceed. Now, normally they'd proceed by indictment in sort of more serious cases. And certainly I believe that was the case with both Nur and Charles, who were charged on this one. But the problem is that they were arguing that this setup was unconstitutional because they said that there were a reasonable hypothetical of somebody who could be charged and could be potentially forced to look at a 3-year mandatory minimum who maybe didn't deserve it. Now, let's start out by just looking at the facts around each of these individuals. So with Mr. Nur, they say, one evening in January 2009, a young man entered a community center in the Jane and Finch neighborhood of Toronto and told a staff member that he was afraid of someone who was waiting outside to get him. The staff member saw someone waiting outside who looked threatening. The neighborhood had very high levels of crime. Gun violence was a serious problem. The supervisor put the community center on lockdown and called the police. When the police arrived, they saw 4 men standing at one of the entrances of the community center. Nur was among them. As one of the police officers approached, the men scattered. The police officer chased Nur. He held his left hand against his body and appeared to be concealing something. As the officer gained ground on Nur, he saw Nur throw something away. The officer caught and arrested Nur moments after. Returning to the area where he had seen Nur throw something to the ground, the officer found a loaded handgun under a parked car. The gun was a working .22 caliber semi-automatic with an oversized ammunition clip. Okay. There were 23 bullets in the clip and 1 in the chamber. The gun is a prohibited firearm. When functioning properly, the gun can fire all 24 rounds in 3.5 seconds. All right, so that's sort of the courts dealing with firearms. Nur was not found to be involved with the threatening behavior, and it was not clear when, for how long, or how Nur came to possess the loaded handgun. So all of these were things that were not proven, so the court's not going to be able to sentence him on assumptions. They're going to only be able to sentence him on what they can prove. There's also some details about his background. He was in high school, he was doing well, he hoped to go to university, work part-time jobs, all the stuff that you usually say in somebody's favor at a sentencing, which is fairly common. Charles, they note, in May 2008, Charles and another man were living in a Toronto rooming house. An incident at the rooming house was reported to the police. They attended it and secured the scene. The emergency task force arrived and searched the house, finding a loaded Ruger semi-automatic handgun and ammunition in Charles's bedroom. It was equipped with an overcapacity magazine, which is a prohibited device under the criminal code, containing 13 rounds of live 9mm ammunition. A further round of ammunition was found on Charles's bed near the gun. The serial number on the gun had been removed. Charles admitted to police that he did not have a license to possess a firearm and did not hold a current registration certificate for the firearm. Charles was arrested and charged with various firearm-related offenses. So the issue then becomes, is this sentence unconstitutional? And as a starting point, when the court is looking at this, they start out here by saying, we're looking at this and we actually think Nur and Charles got the sentences that they deserve, which is a bit of a kick in the pants for those two. So in terms of the sentences they got, Mr. Nur got a little bit over 3 years, and Mr. Charles had a bit more of a record, and he got 7 years. And again, the Supreme Court said, we're okay with those sentences. We think that with respect to these two, those are the appropriate sentences. But they don't stop there. They say, let's go on and look at whether this creates constitutional problems in terms of this setup where by summary conviction it goes up to a year, and by indictment it goes down to a minimum of 3 years. So what they decided here, what they were doing was looking at reasonable hypotheticals. And what a reasonable hypothetical means is essentially some scenario where you could see somebody being charged here and facing a grossly disproportionate sentence to their actions. So that's basically what they're saying here. And they note here that it can't be far-fetched. It can't be something sort of ridiculous or bizarre, but it should be something, it also doesn't need to be the most common scenario. All it needs to do is show that some proportion of the people charged could be affected, and that it's not some, sort of tiny, minuscule, unlikely scenario. Now, the Crown had an interesting argument on this one. What they said is, first, that the defense couldn't point to a specific case where an actual injustice had happened. And they said, second, that because there's the Crown discretion to proceed summarily rather than by indictment, we'd know that there wouldn't be any injustices because the Crown would just choose to proceed summarily and would never seek to proceed by indictment and thereby oppress anybody. So we can rely on the Crown, and that's going to solve our problems. And they said, and if we're doing it wrong, they can bring an abusive process application. Now, the court doesn't really like this argument. They don't go along with it. And the first reason is that they note that abusive process, they say it's a notoriously high bar and has no place in this court's jurisprudence under Section 12 of the Charter. As the defense, it's very difficult to establish an abusive process on the part of the Crown. It's a very rarely successful argument, rarely made and rarely successful. They also go on to note, 2 further objections may be raised against the argument that prosecutorial discretion can cure a sentencing provision that violates Section 12 of the Charter. The first is that one cannot be certain that the discretion will always be exercised in a way that would avoid an unconstitutional result, nor can the constitutionality of a statutory provision rest on an expectation that the Crown will act properly. And they cite some cases for that, going on to quote, unfortunately, it would seem that whenever the Crown is granted statutory power that can be used abusively, then, on occasion, it will indeed be used abusively. The protection of basic rights should not be dependent upon a reliance on the continuous exemplary conduct of the Crown, something that is impossible to monitor or control. Rather, the offending statutory provision should be removed. They say this leads to a related concern that vesting that much power in the hands of prosecutors endangers the fairness of the criminal process. It gives prosecutors a trump card in plea negotiations, which leads to an unfair power imbalance with the accused and creates an almost irresistible incentive for the accused to plead to a lesser sentence in order to avoid the prospect of a lengthy mandatory minimum term of imprisonment. As a result, the determination of a fit and appropriate sentence, having regard to all the circumstances of the offense and offender, may be determined in plea discussions outside of the courtroom by a party to the litigation. So what they're saying, and they go on to sort of add, we cannot ignore the increased possibility that wrongful convictions could occur under such conditions. What they're saying is that, if you're sort of an ordinary person, you've committed an act of less serious nature, the Crown could say, listen, if you take this to trial, we're going to proceed by indictment. But if you take the deal, we'll give you just, 3 months in jail or maybe no jail time. We'll just give you a firearms ban. And, if you're thinking, do I take a firearms ban only right now, or do I risk 3 years in jail? Lots of people are going to say, I can't risk 3 years in jail, even if they're innocent people. So this is the court saying we can't give that much power. And when you think about who they're giving that power against, that power wouldn't do much against somebody like Mr. Charles, who's looking at 7 years. You can't go to Mr. Charles and say, listen, if you don't plead out, we're going to proceed by indictment. Because he's going to say, no kidding. Of course you are, because I've done a whole bunch of bad things and these are bad circumstances. The people who they can use that power against are the people who have committed much less morally blameworthy actions. So this, to my mind, is a very trenchant concern, it's one that I'm glad the court had in its mind. So next, it's worth looking at what sort of reasonable hypotheticals the court is dealing with, because these are the kinds of people who might have been subject to a Crown potentially using the option to proceed summarily or by indictment as a weapon, or who might be subject to grossly disproportionate sentences. So these are actually the kind of people that the court is looking out for when they're making this decision. They're not making this decision for Mr. Nur, and they're not making this decision for Mr. Charles. They're making it for these kinds of people. So let's have a look at who they're talking about. The first scenario they give is for someone who has a valid license for an unloaded restricted firearm at one residence and instead safely stores it with ammunition in another residence, so at their cottage rather than their dwelling house. And the Attorney General of Ontario objects that this is a speculative scenario. On the contrary, occurrences such as this are reasonably foreseeable. In the Queen and MacDonald, this court was concerned with a charge against a gun owner who, unaware that his license was confined to his Calgary residence, had it in his possession at his Halifax residence. The court, contrary to what the Ontario Court of Appeal assumed in its example, took a broad view of the offense, holding that the Crown is not required to prove that the accused knew that possession in the place in question was unauthorized, and upheld Mr. MacDonald's conviction. The court commented that in ordinary circumstances, his mistake of law would be a mitigating factor to be considered in fashioning a sentence that is proportionate to his crime. So this is a first example, is somebody who's essentially screwed up in terms of knowing where they're allowed to keep their restricted firearm. And they go on to note, similar examples can be envisaged. A person inherits a firearm and before she can apprise herself of the license requirements commits an offense. This one's a little bit weird because when you inherit a firearm, typically you are getting it through operation of law, and typically you would not be committing an offense. So the Supreme Court seems to maybe be getting the law wrong there. I'm not sure. Awkward. Anyway, they say a spouse finds herself in possession of her husband's firearm and breaches the regulation. We need not focus on a particular hypothetical. The bottom line is that Section 95 sub 1 foreseeably catches licensing offenses which involve little or no moral fault and little or no danger to the public. For these offenses, 3 years imprisonment is grossly disproportionate to a fit and fair sentence. Firearms are inherently dangerous, and the state is entitled to use sanctions to signal its disapproval of careless practices and to discourage gun owners from making mistakes, to be sure. But a 3-year term of imprisonment for a person who has essentially committed a licensing infraction is totally out of sync with the norms of criminal sentencing set out in the Section 718 of the Criminal Code and legitimate expectations in a free and democratic society. As the Court of Appeal concluded, there exists a cavernous disconnect between the severity of the licensing type offense and the mandatory minimum 3-year term of imprisonment. So when we think about this, if you consider the example that leaps to my mind, and doesn't appear to be one that the court considered here, but let's say your firearms license expires, and as you're a owner of restricted firearms, you have those, and you probably also have ammunition, because most people who own guns keep ammunition because it's useful. If you want to go to the range, it's nice to have, especially because many ranges don't have a store there to sell ammunition. You don't want to have that additional stop, especially given that you can't really take your gun on that additional stop. It's not like you can take your gun and stop at the gun store. You actually have to go to the gun store, get the ammunition, come back to your house, pick up the gun, and then go, which is a pain. So people keep some ammunition on hand. Also, it doesn't go bad, at least not if you treat it properly. But the day that person's license expires, they're committing an offense, possession of restricted firearm without a license together with ammunition. And they might have a renewal pending with the chief firearms officer. They just didn't get rid of their guns. Does that person deserve 3 years? It's really, I don't think you'd find many people who would say yes. Maybe sort of a few anti-gun zealots would say, yes, 3 years is the appropriate sentence. But for most Canadians, they'd probably go, no, that's way too high. So again, Supreme Court here is looking out for the ordinary gun owner who makes a mistake, rather than people like Nur or Charles, who were less so much making a mistake and more involved in bad life choices. And once again, the Attorneys General of Canada and Ontario argued that the Court of Appeal erred by not taking into account the Crown's ability to elect to proceed summarily and thereby avoid the mandatory minimum sentence in the indictable offense. They argued that the hybrid nature of the offense should be taken into account as a factor when assessing the likelihood that a general application of the offense would result in a grossly disproportionate sentence being imposed. Put differently, they contend that the Crown's election to proceed summarily and thereby avoid a mandatory minimum prevents Section 95 from being grossly disproportionate when the conduct is at the less serious end of the spectrum. And the court says, I cannot agree. To accept this argument would result in replacing a public hearing on the constitutionality of Section 95 before an independent and impartial court with the discretionary decision of a Crown prosecutor who is in an adversarial role to the accused. Sentencing is inherently a judicial function. It is the courts that are directed by Parliament to impose a mandatory minimum term of imprisonment, and it is the duty of the courts to scrutinize the constitutionality of the provision. The Crown's submission is, in effect, an invitation to delegate the court's constitutional obligation to the prosecutors employed by the state, leaving the threat of a grossly disproportionate sentence hanging over an accused head. Again, they don't want to leave this power in the hands of the Crown alone because they're worried that the Crown would abuse it and that the Crown would use it particularly to force guilty pleas. They come out and say that directly. So I think this is a great decision. I don't have a whole lot of sympathy for Mr. Nur or Mr. Charles, but neither did the Supreme Court. You know, people said, oh, the Supreme Court is, being so nice to these guys. No, the Supreme Court doesn't care about Nur and Charles in this particular case. They said, those guys deserve what they get. But they said, we need to step in here because this is something that could be used to harm the ordinary gun owner who makes a small legal mistake. It's nice to know the Supreme Court is looking out for us at least a little bit on gun issues, right? Because there's a lot of decisions where they kind of swing the other way. So I appreciate the heck out of this decision, and I wanted to share it with you, especially because there's a lot of people who were commenting on the last video and, Mr. Bissonnette saying, well, it's all well and good that the Supreme Court is looking, or that the Quebec Court of Appeal in that case is looking out for, dangerous criminals, but they don't do anything for you or I. Here they're doing something for you and me. So anyway, thank you for watching. Please like, share, and subscribe if you want to see more content. So I want to give a shout out to my Patreon supporters. At the $50 level, George, Demo, and People of Canada. At the $30 level, Steve Browning, and $20 from Kevin Fleet and Dale Nesbitt. And at the $10 level, My Buddy Keith, Process Eng, Stephen Larson, General Counsel of the CCFR, John Robinson, Tim Rogers, Roy Haddock, Freckles Dack, Jean-Alexandre Tessier, Cameron Johnson, Sir Goat, Sights and Arms Limited, Chaba Hollow, Peter H., Craig Kwan, Akin Coxall, North Central Process Service, Toys Are for Boys, Ian Vaughn, Milan Vrekic, Terrence Griffiths, Doug Thompson, Mark D., Brad Crooker, Jason Harrington, Lee Kiso, Mark Stout, Michelle Stotzel, Scott Sweetman, Mike Rhodes, Alvaro Bataille, DF, Stacey Cartmel, Tactical Advantage TV Canada, Ian S., Dave Leslie, Juan, Donald Duncan, Stephen Conquest, Darren Duell, Sean Crane, Ian Hutchinson, Rory, Travis, BC Bushcraft Leather. I checked them out. They do some nice work. John Singardi, Misa Komarevich, and David Moga. Thank you once again, and I hope this has armed you with knowledge.